Good afternoon, and welcome to Baker Donelson's Financial Services webinar on key trends and cases from 2022. This is Christine Roberts. Preston and I are members of our Financial Services Litigation and Compliance Group. We focus our practices on defending banks and other financial institutions in a variety of litigation matters. We're excited to present this program and discuss litigation trends impacting the financial services industry, understanding how litigation is developing, and what theories and defenses are gaining traction is critical for banks and other financial services firms. We hope that today's webinar will provide a helpful overview of the major trends we're seeing in both new case filings and recent court decisions. We will also be sharing strategies for preparing for and avoiding litigation. Before we get started, here are a few housekeeping notes. There is a Q&A box on your screen. Please feel free to submit questions in that Q&A box. If we don't get to your questions, we will contact you after the program to follow up. A PDF of our presentation is available in the resource list, and it will be emailed to all of you who are attending in the coming days. Also important is hearing feedback from you. Please complete the survey that you'll be receiving at the end of the webinar, as we're very interested in hearing your thoughts about today's webinar, as well as future programming that we can offer. And this is really important. To receive CLE credit, you've got to do two things. You have to be present for the full webinar, and you also have to click on the pop-ups or poll questions that you'll be seeing during today's presentation. So please be mindful of that, and we'll try to provide reminders. We have organized our presentation today into two parts. First, we'll be talking about 5 litigation trends that Preston and I have observed over the past year. And then the second half of our presentation is going to be talking about the 5 cases that we've observed over the past year and we think are going to have a significant impact on the legal landscape going forward. Preston is going to start our discussion of trends to be aware of. So take it away, Preston.
Thanks, Christine. So the first trend that we have noticed has been kind of a groundswell of litigation and putative class actions that have been filed across the country against banks and also the operator of Zelle, which is a peer-to-peer payment service that is linked to customers' bank accounts and allows customers to send money to other people through their service, very similar to Venmo or PayPal, as many of you may be familiar. The litigation that has been popping up around the country and has also received some scrutiny from regulators like the CFPB and from certain members of Congress involves Zelle scams, where someone is a scammer impersonates a bank representative or someone else and has the customer send money that is actually turns out to be fraud. The lawsuits that have been popping up around the country have alleged that banks are not doing enough to combat fraud with Zelle scams, and they are not warning that Zelle might be an unsafe product. So under the current landscape, Regulation E, the Electronic Funds Transfer Act, together with Reg E, which is what implements the EFTA, provides a basic framework that establishes the rights, liabilities, and responsibilities of participants in electronic banking. However, consumers are generally responsible for transactions that they authorize, which they are actually using Zelle to send money to another person. And so under Reg E, that can be a transaction that they authorize. With that said, financial institutions do have duties under Reg E to investigate electronic fund disputes and to limit customer liability, even when the customer was negligent in allowing the transfer. So that has been put into the filings that have popped up around the country this last year. Elizabeth Warren, Senator Warren, came out with a report kind of highlighting issues with fraud with Zelle. The American Bankers Association issued a response letter recently pushing back on the Warren report and also showing what banks have invested in to combat fraud on Zelle, showing that the majority of Zelle transactions do not have issues. And then if you've seen in the Wall Street Journal and the New York Times over the last couple of days, a group of banks have actually gotten together to decide to come up with a rule to reimburse certain customers for fraud or unauthorized payments that occur through Zelle. That rule that is being considered, it actually just applies to when someone impersonates a bank representative, and it may not apply in other situations. But the rule that the banks are considering or the policy is that if banks determine that a customer was tricked into sending money, then the bank that houses the deposit account where the funds were sent would return the money to the victim's bank, and then the victim of the scam would get a refund from the bank. So, like I said, the recently filed class action complaints allege that banks improperly market Zelle as safe and secure and do not adequately disclose to its customers the risks posed by Zelle. The defenses that have been filed in these cases, there are several cases in California, several in New Jersey, and in North Carolina as well. The defenses are that under the current regulatory framework, the EFTA and Reg E do not require reimbursements of authorized electronic funds transfer, and then also looking at some of the language in customer agreements. So we should see some development, though, with the rule or the policy that the banks that own Zelle are considering. And so stay tuned for that. Some potential action steps that you can take are to train staff on Reg E requirements, ensure compliance, also monitor increased activity by regulators, examining reported fraud in the peer-to-peer money transfer space, and then also just look for these developments that are coming from banks. If you are not with one of the banks that is considering this rule or policy, stay tuned for that. Also, there's a very helpful FAQ that the CFPB put out, I think, within the last year, kind of addressing its stance on unauthorized transfers and what banks need to be doing to ensure compliance with Reg E. So with that, I'll turn it back over to Christine to discuss recent trends in fee litigation.
Thanks, Preston. And I'm primarily talking about overdraft fees and insufficient funds, or NSF fees. Class action lawsuits relating to these types of fees have been around for decades. The cases date back to the late 1990s and were initially focused on the practice of posting items to checking accounts from high to low in terms of the amount of the transaction. From one perspective, this ensured that account holders' most important transactions, like mortgage payments, were paid and paid first. From the plaintiff's perspective, they argued that this practice led to additional or excessive overdraft fees. In the wake of these types of lawsuits, the OCC, the FDIC, the Federal Reserve, and the National Credit Union Administration issued joint guidance on fee practices. They directed banks to ensure that their disclosures regarding overdraft practices were clear and allowed customers to opt out of overdraft protection altogether. And then following that, in I think it was 2009, the Federal Reserve amended Regulation E, requiring financial institutions to obtain an affirmative opt-in from customers before charging them fees on one-time debit card or ATM transactions. Since that time, there have been, continually evolving theories and causes of action. Today, in the current landscape, this is something that the CFPB is very focused on. We've heard from Director Chopra about what he calls the bank's deep dependence on overdraft fees. And we included this quote because it's reflective of other statements that the CFPB has been made about banks purportedly being hooked on overdraft fees. We've seen a number of banks eliminate or significantly curtail overdraft fees. And yet, while all this is going on, we see class action lawsuits continue to be filed across the country in state courts and federal courts in lots of jurisdictions. There are a lot of theories out there and a lot of different types of these cases. For a while, we saw the authorized positive settle negative cases kind of at the forefront. Those involved banks authorizing debit card transactions at a time when a customer had enough money in their account to pay. But by the time that transaction actually got to from a merchant to the bank, the customer no longer had funds in their account to pay it, resulting in an overdraft. We also saw cases involving how balances are determined, cases involving multiple NSF fees when a merchant would send a check or when a merchant would try to present a check multiple times on the same item. We also saw cases about the Regulation E model opt-in form that was created by the Federal Reserve. And even though it was a form created by the Federal Reserve, plaintiffs have complained that that form is not clear enough. We've seen cases involving foreign transaction fees when customers purchase items in the U.S. from a foreign merchant, and there are fees applied to those transactions. We've seen out-of-network ATM fees. Those cases have been prevalent as well. As a whole, these cases have had traction because there were some early successes for the plaintiffs, and that led to more and more of these cases being filed. We've seen over time, it's kind of a mixed bag of wins and losses for defendants at the motion to dismiss stage. And we've also seen that if the cases survive motions to dismiss, they typically settle as opposed to going forward to a motion to, for summary judgment or even trial. And so that initial motion to dismiss stage is very critical. And it also means that avoiding litigation altogether is very important. And so, what kind of things can you do to avoid these cases or best prepare for them? Being on top of the regulator activity is really important. As we've noted, this is an area of intense regulator interest, not just the CFPB, but the OCC and others. It is important to, stay on top of your account documentation and make sure that what you say your practices are in documentation is reflective of reality, as well as, reviewing vendor agreements, since so many, a lot of institutions use vendor forms for account documentation. And then it's also important to be aware of your jurisdiction and what kind of cases are being filed, as well as what kind of decisions are coming out of the jurisdictions where you have operations. It's also always important to monitor customers' complaints and try to resolve them favorably to the customer in ways that might prevent customers from turning into plaintiffs. and also being aware of your insurance coverage and whether that can be of assistance in these types of claims. All right, Preston, you want to address the rise in FCRA litigation?
Sure. Thanks, Christine. So litigation under the Fair Credit Reporting Act has continued to rise over the last couple of years, while we have interestingly seen the number of filings for Telephone Consumer Protection Act cases and Fair Debt Collection Practices Act cases decreasing. Through July 31st of this year, FCRA cases were up 4.1%, whereas FDCPA and TCPA suits were down pretty significantly. And we saw the same trend in 2021 and last year as well. For those of you who don't know, FCRA is a consumer protection statute that places duties on consumers, on consumer reporting agencies, and it limits the use of consumer reports to certain instances and places duties on furnishers of that information to consumer reporting agencies. While maybe historically you might think of a consumer reporting agency as the big three like Equifax, it can really reference any company that regularly assembles information and provides it to third parties. And there are many, alternative consumer agencies out there that track, tenant histories, insurance claims, and checking accounts. And that's one of the big factors that could be driving this uptick in litigation. While in the past the plaintiffs bar might have focused on the big three credit reporting agencies and classic credit furnishers, we are kind of in the age of big data now, and with the broad scope of who can be a CRA, and with data being sold and tracked kind of all over the place, that I think you'll continue to see a rise in these cases being filed. So what are the kinds of cases that are being filed? Kind of your we continue to see a steady stream of individual inaccuracy claims, the kind of "that's not me," "you're reporting my balance wrong," "I was the victim of identity theft," and those cases are being filed and proceeding with a regular clip. But in terms of seeing what's a bit more trendy, we've seen a focus on cases challenging public record reporting. So really the background screening, background check industry, criminal records, civil judgments, whether they're being picked up from the courthouse or by a vendor. There have been several cases filed kind of challenging the completeness and the accuracy of that information. So I got kind of another, here's a polling question for you, which, since this is for CLE credit, even if you don't know the answer or don't want to respond, you probably need to respond in order for us for tracking purposes. But in addition, to the kind of broad definition of a CRA, what might a FCRA case, what might make a FCRA case more attractive to a plaintiff's lawyer? What feature makes FCRA maybe more attractive than the TCPA or the FDCPA? I'll give you a couple moments to respond. I can track on the bottom what the percentage of folks who've answered. So just waiting for that to get a little bit higher up, and then we can go on to the next slide. Okay, well, not a big deal if you didn't answer. But unlike the FDCPA and the TCPA, FCRA does not have a cap on damages. They can be either actual damages or statutory damages of up to $1,000 per violation, and those can add up pretty quickly. And even in individual cases, FICRA cases, they can lead to some pretty big judgments. And then on the class basis as well, that can grow. So I wanted to talk about kind of three areas in which we've seen FICRA cases filed and some of the results from those cases. A big development in FICRA standards in recent years was the passage of the CARES Act in the response to the COVID pandemic in March of 2020. And Congress actually amended FICRA to assist consumers struggling to make monthly payments and obtain credit. The Horvath versus J.P. Morgan Chase Company case from the Southern District of California, the plaintiff claimed that Chase's reports of delinquent payments to credit reporting agencies were inaccurate or misleading because the account was subject to a COVID deferral. The court there held that the plaintiff does not have a private right of action under the CARES Act to enforce its provisions. And additionally, the plaintiff failed to plead that she notified the CRAs that she disputed the reporting as inaccurate. The court held that an allegation of trade line inaccuracy stemming from a CARES Act deferral does not absolve a plaintiff from first having to dispute the trade line with the credit reporting agency. So the motion to dismiss in that case was granted, but the court did grant leave to amend. Also, while waters may be muddy concerning when a permissible purpose exists to obtain a consumer report, the case of Shockley versus Clarity Services from the Western District of Wisconsin can shed some light on how a court will analyze this issue at various stages of litigation. So in that case, the plaintiffs are Wisconsin residents that approached short-term lenders for extensions of credit, and the lenders obtained a consumer report from the defendant. The plaintiffs alleged that the defendant violated FICRA by furnishing credit reports based solely on the lender's promise that it had a permissible purpose for obtaining the information without obtaining the written consent from the plaintiffs. The Clarity filed a motion to dismiss, which was granted, and the court held that the defendant was entitled to rely on representations made by the lenders, that they would use the consumer reports for permissible purposes. The actual purpose for obtaining a consumer report was irrelevant to Clarity's liability. And third, the court held that a consumer does not need to consent before a party obtains a consumer's report if the agency has a reason to believe that the recipient has a permissible purpose. And then finally, in terms of investigations and accuracy of trade lines, Section 1681 S2B has resulted in significant litigation over the last several years to determine, which investigations are reasonable and how furnishers should report different fact patterns. I'll let Christine, she's going to talk about the Bibbs case from the Third Circuit later, but I did want to talk about the Hussey case in our own backyard in the Western District of Tennessee, in which the plaintiff alleged that his student loan servicer furnished an inaccurate trade line to the credit reporting agencies when it included a notation indicating that an account was in dispute. The defendant agencies forwarded the dispute letter that the plaintiff sent to the CRAs indicating that he no longer disputed the account. They sent that to the loan servicer, but the account and dispute notation was not removed. The loan service defendant filed a motion for judgment on the pleadings, which the court granted. It was Judge McCullough in the Western District of Tennessee, and he held that where a consumer sends a letter to a credit reporting agency requesting the removal of a dispute notation, but never actually terminates a dispute directly with the furnisher, a furnisher cannot be liable as a matter of law. So so potential action steps that you can do, it's just very important first and foremost to maintain a culture of compliance, to monitor not only employees' compliance, but also systems that are in place, and then just continue to monitor developments from courts or pronouncements from the CFPB or FTC that require furnishers to change their forms or change their approach. That's it for FICRA litigation, and I'll turn it back over to Christine for PPP-related litigation.
Thanks, Preston. As everybody knows, Congress passed the CARES Act in 2020 in the midst of the COVID-19 pandemic, which provided nearly $1 trillion through the Small Business Administration, SBA. Not surprisingly, lawsuits resulted. The initial lawsuits primarily stemmed from the fact that Congress initially had a pool of money, and there were questions about which applications were prioritized. There were also cases filed by so-called agents of borrowers who had facilitated these loans. These federal cases were largely dismissed, and the courts held that there's no private right of action under the CARES Act against banks. And what we've seen more recently are two trends we wanted to highlight. One is we're seeing some cases being brought in state court under various state law theories, whether it's negligence or breach of contract. And so we wanted to highlight for you that we are seeing some of these cases being filed by either entities that did not receive PPP funds, or they did not have their loans forgiven, and they're pursuing financial institutions regarding those claims. And so that's still very early, but we did want to highlight that those cases are getting filed. And so it's important to be aware of the processes you had in place to comply, and to keep those records, including from rejected applicants, so that you can validate your procedures and what you did. Also, we wanted to highlight that another possibly emerging trend is government enforcement actions. 2 months ago in September, the DOJ announced what's called its first ever settlement with a bank to resolve allegations that bank processed a PPP loan for an ineligible borrower. Now, you may recall that the SBA's interim final rule had allowed lenders to rely on borrower certification and documentations regarding eligibility. And in this case, what the DOJ was focused on is that they found that, or alleged that, the bank had actual knowledge that the borrower's sole owner was facing criminal charges, and thus that borrower was not eligible. And it's remains to be seen what may come from this, but the DOJ also announced in September the creation of three, what it's calling strike force teams to go after COVID-related fraud. And around the same time, Congress passed legislation creating a 10-year statute of limitations for PPP-related fraud. So this may be with us for some time. All right, Preston, you want to talk about our final trend involving data incidents?
Yes, I do. First, one thing, I did see a question pop up asking if there's fee shifting under FICRA, and just very quickly, yes, there is fee shifting under FICRA. But turning back to cases involving data incidents, obviously this is a very hot button issue that has been on kind of everyone's radar. You've seen these kind of big settlements or big dollar amounts going around for breaches of companies' data. Kind of one that's been in the headlines this year was a wireless telecommunications company that reported a data breach that included records for more than 40 million customers. The company agreed to pay a $350 million settlement to a class action lawsuit arising from the incident, and to devote significant funds to data security in 2022 and 2023. Some kind of different cases that have popped up, not relating to data breaches specifically, but just things that I thought were very interesting in what I've seen this year. But in September of this year, the Northern District of Ohio sanctioned the defendants in the case as a trademark dispute for spoliation of evidence. And the defendants had argued that they actually changed their data policies because in order to comply with the California Consumer Privacy Act and the ISOC. The court did not buy it. Basically because of some timing issues that existed in that case. They changed their data policies 10 months after the hold letter went out and after the litigation was filed. And so the court found that, well, first of all, when they did switch data systems, it deleted a lot of messages on their internal messaging system. And the court sanctioned the defendants with an adverse inference. And so it's just very important for all of you to remember that when hold letters go out, to put those in place. And also, if you are considering changing your data retention policies after an event like that or while litigation is going on, make sure that you're not going to lose a bunch of data as a result of that. Also recently, the FTC and a consumer loan data seller entered into a proposed settlement holding the executives of this lead generation company liable for unlawful practices in the course of their business, which included selling the personal information to non-lenders or using it for marketing purposes. So when I was talking about FCRA earlier, and you can take a lender's word that they're using it for a reasonable purpose. What you can't do is you can't sell this or send this information to non-lenders. And there was a $1.5 million penalty asserted there. So another thing that's really important to talk about are the regulatory developments in this space. There has been a lot over the last couple of years, but the ones I wanted to focus on are the Computer Security Incident Breach Notification Rule, which actually is in effect now, went into effect in May, and it's a pretty intense rule. A bank must notify its primary regulator within 36 hours after determination that a notification incident has occurred, and a notification incident is a computer security incident that has materially disrupted or degraded critical banking operations. So that is one to really pay attention to, and hopefully everyone on here is in compliance with that already. Also, the NCUA recently proposed a rule that mimics pretty closely the bank rule, but importantly, the requirement to report an incident is within 72 hours after a credit union reasonably believes that a reportable cyber incident has occurred. So that's kind of more in line with what we've seen elsewhere. Also, in August of this year, the CFPB published a circular answering the question whether entities violate the prohibition on unfair acts or practices in the CFPA when they have insufficient data protection or security, and that was met with a resounding yes. And the CFPB pointed to 3 practices: inadequate authorization, poor password management, and lax software updates as examples. Also, you'll see that the ADPPA, it was kind of put on pause over the summer, heading into the midterms, but I would expect to see that brought back up again. Also, the Cyber Incident Reporting for Critical Infrastructure Act was signed into law by President Biden in March of 2022. It's also important to be up on the 5 states that have passed comprehensive privacy laws. California previously had one, but their new one is going into effect in 2023. And the other states that have passed these laws, they're also going into effect in 2023 as well. Things that we all can be doing, you can be doing to ensure compliance and to avoid data breaches. Evaluate your vendor management programs. Conduct and review results of data mapping exercises ensure that you've got the appropriate insurance coverage, and review your employee handbook or other policies. Also, what you can do is talk to people who are far more knowledgeable than Christine or I about data protection, cybersecurity. We actually have a dedicated team of professionals led by Matt White and Alex Koski, and feel free to give them a call or shoot them an email and talk to them to make sure that you are in compliance and anything else. So I'll switch over to the case assessments and turn it back over to Christine.
Thanks, Preston. So for the remainder of our program, we're going to talk about 5 cases we think are going to have a meaningful impact on banking and financial services litigation going forward. I'm going to start with Hunstein v. Preferred Collection and Management Services, which was a case involving the Fair Debt Collection Practices Act and was most recently decided by the 11th Circuit in September. This case involved a debt collection agency that used a vendor to send out letters. And so the debt collection agency provided a vendor information about this debtor, his son's name, and the amount of the debt. And the debtor sued, claiming that this violated the FDCPA because the debt collection agency disclosed information to the vendor, which was a third party, and that purportedly violated the FDCPA. The district court disagreed and dismissed the case, saying that that was not, that sharing of information with the vendor did not violate the statute. And then when it got to the 11th Circuit on appeal, the 11th Circuit procedural history is pretty complicated. The 11th Circuit panel that was assigned to the case initially requested supplemental briefing on the issue of standing. And as I'll talk about, what ended up being the main issue at the 11th Circuit was this question of standing under Article 3 to bring suit. A couple years ago, the 11th Circuit decided the case of Moransky v. Godiva Chocolatier, and under that court's analysis, the court decided that while some statutory violations can cause real harm that supported a finding of standing, one way to evaluate alleged statutory harms was by comparing them to traditional common law tort claims. And so what happened was the 11th Circuit requested supplemental briefing on standing and found that Hunstein's alleged harm, the fact that the debt collector shared his information with the vendor, was close enough to the tort of public disclosure of private facts that there was standing to proceed with the claim. After that, the Supreme Court in 2021 decided the TransUnion v. Ramirez case, explaining what a plaintiff has to show to establish that an alleged intangible harm is a concrete injury. And after that case, the 11th Circuit panel vacated its first opinion and issued a new one, but ultimately came to the same result, finding that there was standing to bring suit, the case could go forward because of the fact that there was a disclosure, and that disclosure was close enough to the tort of public disclosure to constitute a concrete injury. At that point, the case went to en banc review, and in September, the 11th Circuit reversed, finding that there was no concrete harm and thus no standing. In the words of that panel, Hunstein does his best to shove a non-public transfer of information into a tort targeting public disclosure, but it just doesn't fit. So what the 11th Circuit panel said is because Hunstein was alleging disclosure to a private party, the vendor, that none of the exposure targeted by the tort of public disclosure is at play. So why does this matter? the rationale applies beyond the FDCPA to other cases. What we saw in the TransUnion v. Ramirez case decided by the Supreme Court in 2021 was that the Supreme Court really emphasized that for intangible harms, like we were dealing with in this case, analogizing to long-standing torts is an important way to determine whether an alleged intangible injury meets the concreteness requirement. So we're going to continue to see this analogizing happening on a case-by-case basis in other cases. That brings us to our next polling question, which hopefully everyone can see and choose. In which of these following statutory contexts, in addition to the FDCPA, can questions of Article 3 standing come up? Please go ahead and mark your answer, and then we'll keep going. We got about 65% people responded. I'm trying to get closer to the 100% before moving on, so that y'all get CLE credit. And I'll kind of give you a hint by saying that a big takeaway here is that we've seen conflicting decisions on standing in a variety of statutory contexts. And this question of whether an alleged intangible harm or is enough of a concrete harm comes up again and again. So let's go ahead to our answer. And 85% of you are right that it's all of the above. All of these examples can involve questions of whether an alleged intangible harm is sufficiently concrete to satisfy Article 3. And so this is why we wanted to talk about this case the Hunstein application of the TransUnion framework is going to come up again and again. It will aid defendants in arguing against a finding of a standing to sue. All right, Preston.
Yeah, so this is the Morgan versus Sundance case, which the Supreme Court took up from the Eighth Circuit Court of Appeals. In the case, very interesting, a employee of a Taco Bell franchise filed a nationwide collective action under the FLSA, but had signed an arbitration agreement. And Sundance started defending the lawsuit, filing a motion to dismiss that was denied, and then unsuccessfully engaging in mediation. Sometime after the lawsuit had been filed, Sundance moved to compel arbitration, and the plaintiff argued that Sundance had waived its right to arbitrate, and the district court found that Sundance had waived its right to arbitrate because it had acted inconsistently with that right and prejudiced Morgan, the plaintiff, through its litigation conduct. The Eighth Circuit actually reversed, saying that Morgan had not been prejudiced by the litigation strategy because the parties had not begun discovery or contested any matters. But the Supreme Court took this up and actually vacated the Eighth Circuit's ruling because despite the FAA's policy favoring arbitration, the court found that the prejudice requirement attached to waiver was not ordinary procedural rules. And the Supreme Court ruled unanimously that the FAA's policy favoring arbitration, it does not mean that a court can devise novel rules to favor arbitration over litigation. And so while there doesn't have to be a showing of prejudice for waiver in other instances, so too with the right to compel arbitration, there does not have to be a showing of prejudice, and that is not part of the equation. So the court explained that the kind of the practical implication, I think, for this is that it's now easier for one party to assert waiver because you don't have to show that prejudice, and this has implications across pretty much every industry in which arbitration agreements are used with either customers or employees. It's important to keep this case in mind because of its broad impact. So it's also important to point out that the court did decline to decide what, if any, role state law may play in determining whether a litigant's conduct resulted in waiver, including state law principles of waiver, forfeiture, estoppel, latches, the kind of classic defenses. So it's important to consider, the benefits of invoking litigation and then delaying to file a motion to compel arbitration, or just going ahead and filing that motion to compel. So that's it for Morgan, and I'll turn it back over to Christine for Bibbs.
Thanks, Preston. Preston noted this case earlier when he was talking about the rise in FCRA litigation. And given our discussion of that trend, we thought it important to discuss one of the more significant FCRA cases from this past year. Bibbs v. TransUnion is a Third Circuit decision that came out in August. That was a consolidated appeal of student loan borrowers who had failed to timely pay their loans, which were then transferred to another creditor. For these borrowers, their credit reports showed that the accounts with their original creditors were closed and the balances on those accounts were zero, but there was also a notation that said account 120 days past due date. And the borrowers asked TransUnion to remove that negative notation. They brought a FCRA action claiming that TransUnion had failed to remove the negative notations. And their argument was that a prospective creditor would incorrectly read the credit report to assume that they were more than 120 days late on loans that were closed. And so because the FCRA has a requirement requiring maximum possible accuracy in credit reports, the borrower claimed that the reports contained inaccurate information and violated that requirement. On appeal to the Third Circuit, the key issue was what was the standard that applied. And interestingly, the district court had applied a reasonable creditor standard, which is what TransUnion had advocated for. And the district court had dismissed the cases applying that standard. And when it got to the Third Circuit, the Third Circuit disagreed as to the standard, but not as to the result. The Third Circuit held that courts are to apply a reasonable reader rather than a reasonable creditor standard, primarily because it's not only creditors that use consumer reports. FCRA contemplates a range of permissible users of reports. And so what the Third Circuit said is the reports must be viewed from that perspective of a reasonable reader. At the same time, the court found in TransUnion's favor on the key question of whether the courts were clear, finding that the reasonable reader standard includes reading the report as a whole, as opposed to focusing on entries in isolation. And so because in this case, the student loan borrower's reports contain conspicuous statements showing that their loan accounts with their original creditors were closed and they owed no financial obligations to their previous creditors, the Third Circuit said there was no FCRA violation here. So this is a case that will be beneficial to both furnishers and credit reporting agencies going forward, as it should help insulate them from borrower claims based on isolated statements or statements taken out of context. And now I'll turn it back to Preston to talk about a case that may be less helpful to financial services firms.
Thanks, Christine. So this is the 11th Circuit case of Daniels versus Select Portfolio Servicing, or SPS. And in the case, the plaintiff had sued the servicer under the Fair Debt Collection Practices Act and also the Florida Consumer Collection Practices Act, alleging that a series of monthly mortgage statements misstated a number of items, including the principal amount due. And she claimed that by sending her incorrect mortgage statements that the servicer violated the FDCPA's prohibition on harassment or abuse. And the 11th Circuit said that, this was a question of first impression, which is whether monthly mortgage statements required by the Truth in Lending Act and its regulations can constitute communications in connection with the collection of a debt under the FDCPA, and the court held that they may, when at least the mortgage statements contain debt collection language, such as this is an attempt to collect a debt. And so the 11th Circuit reversed a grant of a motion to dismiss that was awarded to the mortgage servicer. And importantly, the servicer in Daniels, no petition for writ of certiorari was filed. And then actually in July of this year, the 11th Circuit reiterated that the respective requirements of the Truth in Lending Act and the FDCPA, they can be approached in a harmonized fashion, and that a periodic statement mandated by the Truth in Lending Act can be a debt collection communication covered by the FDCPA. So there was a dissent filed in the case, and kind of criticizing the majority's opinion and saying that, having this kind of having basically, if you use the magic words that this is an attempt to collect a debt, that it can trigger these issues. And the majority opinion really went out of its way to say that that it was not creating a circuit split on the significance of the first disclosure and communication, and that it went very far out of its way to say that it was not expressing an opinion on the ultimate merits here. But in terms of takeaways, be aware of the potential issue with including this as an attempt to collect a debt in written communications, and then decisions in favor of creditors on motion to dismiss may become less likely in the future. So I will turn it over to Christine for our fifth and final case.
Thanks, Preston. We couldn't talk about significant cases from 2022 without talking about the Fifth Circuit's ruling in October, holding that the CFPB's funding mechanism is unconstitutional. That case also dealt with the 2017 payday lending rule, and as a result of its ruling, that the court vacated that rule. But the major question is as to the CFPB's the constitutionality of its structure and how it's funded. As a background point, since the CFPB was created, There have been multiple challenges to the constitutionality of its structure. Y'all may remember 3 years ago in the Celia Law case, the U.S. Supreme Court held in a 5-4 decision that Congress violated the separation of powers doctrine by placing the CFPB under the control of a single director removable by the president only for cause, as opposed to at will. However, the Supreme Court did not invalidate the entire agency, as we all know, for the structural flaw, but severed that for-cause provision from the rest of the CFPB's authorizing statute. In this case, the core issue that the Fifth Circuit grappled with was how the CFPB was funded, which is through request to the Federal Reserve. The CFPB argued that this satisfied the appropriations clause because Congress created the CFPB, through a law that set up this funding mechanism. The Fifth Circuit did not agree with the CFPB's reasoning and found that the funding mechanism did not satisfy the appropriations clause of the Constitution, which states that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. Unlike most executive agencies which rely on annual appropriations, the CFPB's funding structure is different. And the Fifth Circuit focused on the fact that the CFPB is insulated from the appropriations process because it comes from the Federal Reserve, which itself is outside the appropriations process. So it found it to be doubly insulated. And that in setting up the CFPB this way, the Fifth Circuit concluded that Congress abandoned its most effective check on the executive branch and, in effect, abdicated its appropriations power. The CFPB has filed an appeal with the Supreme Court. Its cert petition was filed promptly, I think within about 30 days. The response to the cert petition is not due until January. But what the CFPB has said in its petition is that the Fifth Circuit's ruling contradicts the Constitution's text, historical practice, and precedent. The CFPB also argues that the severability clause in Dodd-Frank means that portions of the funding mechanism can be struck down without jeopardizing, the entire CFPB. But obviously, this case has significant implications. The petition itself contends that the ruling by the Fifth Circuit calls into question virtually every CFPB action since the agency was created in 2011. If the Supreme Court affirms the ruling or lets it stand, it could affect all of the CFPB's rulemaking, enforcement actions, and related actions since 2011. In the meantime, we're seeing litigants in cases across the country citing the Fifth Circuit's ruling as a basis to challenge the CFPB and defend against administrative actions and enforcement proceedings. While at the same time, the CFPB is continuing its oversight, rulemaking, and enforcement activities unabated. So much, remains to be seen as to where this all lands. The CFPB is asking the court to hear argument this term and reach a decision by June. So, we will all be watching to see what happens with that, but thought it was important to include in today's presentation. A few final notes. We will be following up with those of you who entered questions in the chat function since we are at the end of the hour. Also, as I mentioned at the outset, we're always looking for ways to better serve the financial services industry. So if you have ideas about future programming, CLEs, webinars we can offer, or other ways our law firm can be of assistance to you, please let us know. So thank you everyone for joining us today. And this concludes our program.